go. Hello, everybody. Good to see you. Welcome in. I know there's a lot of excitement going on with Cory Booker, so keep me posted on how that's going. All right, I would appreciate it. Thank you very much. Yes, I think he is setting some records. Hello again, Kaya. Hello. Good to see you. Boy, this Cory Booker situation is like, yikes. Oh, he's wrapping up, really? Okay. Very exciting, though. Very exciting. I'm just very pleased to see this kind of action. Very pleased about it. I think it's great. Hello, welcome everybody. So unique, yes. Okay, sounds good. Jennifer, hello. Tat, he just broke the record. Okay, Morning Star, welcome. VC, always a pleasure. Laura, hello, welcome. Ellen, hello, welcome. Okay, yeah, he had some stuff to say. I thought it was fantastic. I was very impressed with that. Oh, lost one seat in Florida. Well, that's all right. All right, so we do have some information coming in on Florida then. We've got 2 seats. I think it's important to note, though, how close it was. How close. Okay. Yeah, okay, so they've called it for the Republican. Still frustrating. Yeah, how close was it, though? I mean, it must have been still pretty gosh darn close, I would imagine. I mean, it's amazing the amount of work that went into the special election. I mean, it's just really amazing. Some people just have no idea it was even going on. Right. Close to 30 point. Really, 9%. That's amazing. That's amazing. I mean, still. So, yeah, but still, everybody. I mean, if it was a given before, but now we're in a situation where I think that's pretty amazing. I think that's great. Those ruby red places now are becoming pale, and that's all right. That's all right. The numbers are going to make them scared because before 30 points. Really? Okay. A lot of movement, exactly. And that's really, it was, fingers crossed that 2 seats could be picked up. And of course, freaked everybody out, the fact that there was even a shot at it. So to come close is like, we love that. Yeah, we'll have to keep our eyes on Wisconsin. I think their polls are still open there. How many people voted versus how many were registered? Oh, that's a good question. That's going to be a valid question to ask. Here we go. Trying to bump up there we go. We'll have to see. I mean, again, though, just to have special elections, getting this much of a voter turnout is amazing. Yeah. Second Florida seat polls are closing now. Okay. Yikes. Yeah. I mean, again, though, this is, we need to get people awake, and hopefully this has done that. Knowing it was right. 15 to 20%. Yeah. Oh my gosh. Hello, Jean Marie. Welcome. I'm so glad you can see the chat. Welcome in. Good to see you. Yes, I was over on the talk doing a pregame show, everybody. But here we are. We're going to do some documents, but giving a chance for everybody to come in and get their notifications going. Hello. Good to see you. I am adjusting my screen here too. There we go. All right, I've got to make sure everything is, there we go. Okay. Fighting with my computer, but in a good way. In a mutual, respectful way. I'm fighting with my computer here. Hello, hello, hello. The 10th Muse, welcome, welcome. Open their video apps. Skylight, really? That's interesting. I'll have to go over there. I was like the first few days of Blue Sky, I was all up in that. But then um, that's not been my favorite format to do the short, kind of quippy Twitter-like things. So I've had to kind of get myself sorted again. Here to see the nails. Yes, so tonight I've got my, I don't know, my red fire nails. I needed a little extra passion tonight. I was like, do I have flames? This is the closest thing I have to flames. So that's what I've got. I'm not sure. I knew they kind of did a whole bunch of stuff on the moon. Like they were throwing stuff and doing stuff, but I don't know everything that they were doing. That's an interesting question. Yeah, less than 1 minute. Yeah, and I just can't get into the swing of it. I think it's just exactly right, Boxer Mom. They are. That's exactly right. Yes, indeed. Hard to break away from Corey. I know. Toggle, everybody, toggle, because you got to give me updates. All right. Well, welcome in, everyone. Welcome in. Please feel free to toggle with the Cory Booker situation because that's flipping amazing. We love that. We love that. Right. So toggle, no worries. Just to remind everybody, we do have probably the biggest case that we're kind of remembering to go through is the JGG case, which is the El Salvador case. Oh, hello from India. Good to see you. Hello, Cynthia. Now, the JGG case, we have actually show cause hearing on the 3rd, everyone. This is a pretty big deal. So that's Thursday, if I have my days correct. Show cause hearing is basically the government needs to come in and explain to the judge why they did not violate the judge's order. So that's going to be a pretty heated hearing. I think this will be kind of our first supercharged hearing. The other ones have definitely been controversial, but I think this one's going to be pretty heated. So we'll have to keep our eyes on that. But for tonight, I thought it would be interesting to take a few minutes and kind of go. I'm going to call it here. Yeah, I love it. Love it. I'll be reporting on it. I'll be listening and then, letting everyone know. Also, why do district court judges have jurisdiction over the president? Right. Let's do a refresher. All right. We have, and that's, I think it's always good to refresh. So we have 3 levels of courts, all right, at the federal system. We have the district court, the Court of Appeals, right? And then we have the Supreme Court, all right? So every case starts in the district court. That's where you start. So you start, wait, the burrito's still here, right? Okay, good. So the district court's where every case starts. So all cases go here. So it's not just the president, it's everybody, even the King of England, all right? So we start at the district court, then we get a decision. Then you can appeal it to the Court of Appeals, and we get a decision, and then you can appeal it to SCOTUS. And this is our federal court system. That's just how it works. That's how it is. There are a couple of original jurisdiction issues where you can jump right into the Supreme Court, but very rare and not involving the president. So there you have it. All right, short and sweet. So what I wanted to kind of take us through a little bit, just a few pages tonight, everybody. Hopefully everyone can see this okay, but we got to start somewhere, right? Is we took a hit. I feel like we took a hit, and by we I mean the precedent that we've had before. the legal precedent. Sometimes our legal precedent needs to be overturned. Sometimes not so much. This one feels to me like not so much, but nevertheless it was. These two cases were consolidated. This is the Harris case and the Wilcox case. We had a member of the Merit Systems Protection Board who had been fired from her position, even though she still had time left on her contract. She still was supposed to be serving for a while. She was fired. She, filed a lawsuit. So the lawsuit went up, and the district court said put her back on the board because, she was supposed to be on the board for a couple more years. And so the government appealed. Next, we have Wilcox. She was on the National Labor Relations Board. She was fired as well. They wanted to put their own people in, and this was a position where the president picked somebody and then the Senate approved. They're supposed to be there for 5 years. It's not supposed to be a political position, really. That's why they had a 5 years on it. She was fired. District court said put her back on the board. These two cases were consolidated because they were a very similar issue. We've got federal boards here where these people were fired. Now, this was appealed. We went up to the circuit. This is the District of Columbia Court of Appeals. And the Court of Appeals said, pull them back off of the boards. Take them off the boards. So the Court of Appeals said, basically, the federal, executive branch can kind of do what they want here. So I thought it would be good for us to take some time and just go through the first few pages of this case to see what this argument is, because this is a huge argument between separation of powers. That's going to be the big issue in the JGG case. Does the executive branch have more power than the judicial branch? And what kind of power does the judicial branch have regarding the executive branch? And those are all good questions that need answers. And I thought this case really kind of shows where some of our judges are coming from when it comes to the separation of powers. So I thought I would go through, again, just the first few pages of this decision. This was a 3-panel set of judges. We had 2 judges that were, conservative judges, and then one judge who was a liberal judge, I guess, if you want to go down that road. So we've got 2 concurrences and 1 dissent. So it was a 2-3 situation on, again, overruling the district court and pulling them back off of the boards. So, it was a lot. So here we go. I thought I'd take us through the beginning of this case. And, the judge here, Judge Walker, sets out kind of what the argument's going to be. So when we're walking through the separation of powers issues over the next few days, over the next few weeks and months, this gives us some insight into what the big issue is. Can the executive branch countersue judicial branch for overreach? So, a valid question. The check on the judicial branch is Congress. Congress checks the judicial branch. The executive branch does not check the judicial branch, all right, when it comes to checks and balances. So the judicial branch checks Congress and the executive. The executive branch doesn't really check anybody. The executive branch is just supposed to be implementing the laws, and then Congress and the judiciary kind of go back and forth in between checking each other. How to prove that someone's violating attorney-client privilege with possible illegal surveillance. Oh, that's a tough one, actually. That's not easy. That's not an easy one. There's no judicial overreach. Right. So that particular term, good point, VC. The term judicial overreach, this is controversial. Do judges, are judges, ruling from the bench? In other words, they're legislating from the bench, right? We're supposed to have Congress. Congress makes the laws. So judges aren't supposed to be legislating from the bench. True, true, true. Some people may see that as judicial overreach, where judges start making law rather than having Congress do it. And so sometimes when that happens, we get a situation where I think the Chisholm case was the first one, really, where the Supreme Court ruled in a certain way, and Congress said, well, that's, we don't like that. And so they passed the 11th Amendment. So you have to have an amendment to overturn the Supreme Court's precedent. And that's happened repeatedly. We've had a ton of those kinds of cases where we've had, I wouldn't say it's overreach, but I would say a decision from the US Supreme Court, and Congress was like, that's rubbish. We can't have that. And they've come in and passed laws. So that's how that works. It goes through Congress. Congress is supposed to keep the courts from going too far by writing laws that come in and put the parameters around the courts. Not judicial. Right. That's a great way of putting it. Yep. That's a great way of putting it. All right. So again, we have the 11th Amendment that was passed because of a Supreme Court decision. For sure that happened. We've had several amendments that have come in order to kind of clean up a mess the Supreme Court has made. And the Supreme Court has made a lot of messes over the years, everyone. They have made some really terrible, atrocious decisions that we have had to fix and recover from over the years. I think that we had, Citizens United absolutely played a huge role, for sure. So let me go ahead and dive in. This is, this particular ruling, I think, is really helpful to get the background of where a lot of our judges are coming from. The other side of the argument on presidential power here. So I think it's really valuable. The best way to really understand or to argue a case is to know both sides of it. So that's what I'm hoping to be able to go through with you tonight. So let me do I need a sticky note here over on YouTube, everybody? As I look to the chat, do we need a sticky note over here? Oh my gosh. Okay, so we won one Florida seat. Yes, please. Okay. Yes. Okay. Hello, Achilles. Hello. Bruce Wayne's mother. Welcome. Okay, it does help. All right, excellent. Okay. Okay, so we got one seat in Florida. Oh my gosh, that's still pretty amazing, everybody. Pretty darn amazing. So let me just write out what case this is. This is Harris v. Besant. And this is the fired board member. Okay. Fired board member. So let's see. Executive versus judicial power. Let's do that. Executive versus judicial power. Okay, there we go. Yeah, I think the Supreme Court situation in Wisconsin is going to, I think they're still voting at this point, would be my understanding. All right, here we go. Okay, we don't know about them yet. Yeah, that's a huge win in Florida. That's amazing. We love that. Let me bump this up. Let me know if, the angle here, if it's too far away or not. I'll go ahead and get started here, everyone, and pass the chat off to my moderators as we start to go through this. Too close to call. All right, that's still freaking amazing, right, for Florida? I think that's amazing. All right, here we go. We have a circuit judge here. Article 2 of the Constitution vests the executive power in a president of the United States and requires him to take care that the laws be faithfully executed. And we have footnote 1 here. It's just a citation. We have citations to different cases down here, so I'm not going to spend a lot of time on the footnotes, all right? To protect individual liberty, the framers created a president independent from the legislative branch. To further safeguard liberty, the framers insisted upon accountability for the exercise of executive power. So they lodged full responsibility for the executive power in a president of the United States who is elected by and accountable to the people. Executive branch agencies do not disrupt that design when they are accountable to the president. But consent of the governed is a sham if an administrative agency by design does not meaningfully answer for its policies to either of the elected branches. That's why the Supreme Court has said that Congress cannot restrict the president's removal authority over agencies that wield substantial executive power. And this is important to know what case this is here. This is the Sela Law v. CFPB case, and this was decided in 2020. The court's precedents control this court's case. Under those precedents, the government's likely to succeed in showing that the statutory removal protections for National Labor Relations Board commissioners and Merit System Protection Board members are unconstitutional. The government has also shown that it will suffer irreparable harm each day the president is deprived of the ability to control the executive branch. Conversely, the removed office officials suffer no cognizable and irreparable harm during the pendency of these appeals, nor do the agencies where they previously worked until the president fired them. Finally, the public interest also supports a stay. The people elected the president to enforce the nation's law, and a stay serves that purpose by allowing the people's chosen officer to control the executive branch. So, language to keep your eye on, everyone, as we fight through this period of time is this, overwhelming. Well, the people chose that person. All right, so this kind of language is what a lot of judges and a lot of people are using to kind of give this carte blanche to Mr. Trump, because they're like, well, he was elected. So, which is true, he was elected. But again, carte blanche doesn't fit within, our framework here. So we have to still have some accountability. I therefore support granting the motions for a stay pending appeals in the Harris and Wilcox case. Here's our background. The National Labor Relations Board and the Merit Systems Protection Board are executive branch agencies. By the terms of statutes that the government argues are unconstitutional, their members may be removed only for cause. All right, so this for cause means you can't just fire them at will here. Okay, I'm double checking out here. Okay, yeah, I'm let me know, everybody. Keep me posted. This is very exciting. On January 27th of 2025, Trump removed Wilcox from the NLRB prior to her term's expiration in 2028. In an explanatory letter, the president informed Wilcox that the board had not been operating in a manner consistent with the objectives of his administration. Citing several recent board decisions, he expressed concern that Wilcox was unduly disfavoring the interests of employers. Wilcox sued for reinstatement on February 5th of 2025. 5 days later, she moved for summary judgment on an expedited basis. After a hearing on March 5th, the district court granted summary judgment to Wilcox, declaring that she remained a member of the board and permanently enjoining the board's chair and his subordinates from effectuating the president's removal order. A similar chain of events occurred in Harris v. Besant. On February 10th of 2025, the president removed Harris from the MSPB. So this is another board, the Merit Board, prior to her term's expiration in 2028. Unlike Wilcox, Harris did not receive an explanatory letter. Man, these people, I tell you, this is just rude. Like, even if you can do it, can you do it in a way that's not so rude? You just wonder. Was Wilcox tenured to ensure a 5-year appointment? Why can't she be let go? Happens in the tech industry. Okay, good question, actually. So, she's hired for a position for 5 years. So, you have to have good cause to remove somebody. That's just the law. That's how the law is written for her job. Her job description's written in the law. It's not in a manual, it's not in, the articles of incorporation. Her job is written in the federal code, in the law, and it says her job will last for 5 years unless there's good cause to remove her. There was no good cause, and yet they removed her before the 5 years was up. That was the thing. Can you get it focusing on the sticky notes? Oh, really? Oh my gosh. I tell you what, everybody, I've really been struggling with my camera's focusing issue here. Right, right. So, all right, how is it now? Is it better? Wait, am I too far? Hold on a minute. Right. All right, how are we now? How are we doing? Is that better? Okay, better? Is it better? Okay, that's good. All right, so I'll try. I'm wondering if it's the pen too. Is it pulling on the pen? Man, I reset all of my stuff too because I had been noticing that happening. Okay. All right. Well, hopefully this will work out okay. Maybe I'll just point to the paragraph. And let's just go paragraph by paragraph so that I don't have so much in the way of the camera. We'll give it a go. All right. We'll see what happens. So anyway, so that's the thing. If you've got at will employees, in a company, you look to see what the company's policy is, right, on what the job description is and how long they're there for. That's exactly what you do. And for us with these jobs, it's just written in the law is all. We don't have a corporation that has a manual. We have a federal statute. And so the question is whether or not that federal statute is actually constitutional or if it steps on the toes of the executive branch, which is, a valid question. It's a valid it's a good question to ask and something to get sorted out. So I don't see a problem in sorting through everything, but I do see a problem with, kind of being a dick about it. So, I mean, there's no reason to actually be a jerk about it when it comes to removing people in this situation. So I think these are great questions to have, and whatever the answer is how it's gonna go. I was just asking a question to understand the case. I feel like this was Apple and not the government. Protection of work should be performative based. It is performative based. The thing to maybe help you understand is private companies set out the rules for their company, right? So Congress set out the rules for our agencies. And this case is about the rules that Congress set out. And the president saying, this particular rule is bogus and it is infringing on my power. And, the court is going to have to assess that. That's what the case is about, and that's what our courts do is to make that assessment. All right, here we go. All right. Harris sued for reinstatement on February 11th. Uh, uh, works for the government as a whole, not the exactly right. I mean, not everybody in the government is actually a political appointment. In fact, the majority of the people that work in the federal government are not political appointments. They're just people working jobs. So right, right. There are some political appointments, and whenever the new administration comes in, of course, when the next president comes in, they're going to get rid of everybody off the top that's a political appointment. That just happens. It's happened since John Adams and Thomas Jefferson. Off the top, the political appointees are out. But our government wouldn't function if we completely rehired or fired people every 4 years. We wouldn't be able to get anything done because the process of hiring and firing would take up so much time, there wouldn't be time for anything else. So, because of that, they had to set rules in place so that some people weren't hired and fired with the whim of the administration, but rather they would have a longer period of time so that, the whole government doesn't get crazy like it is right now. All right. All right, we got it. We got it. Uh, yeah, we'll have to see. We'll have to see. Expected them to be. Yeah, we'll see. We'll see, everybody. All right, moving on. Moving on. Here we go. Harris declaring that she remained a member of the board and permanently enjoining various government officials from executing the president's removal order. In defending these removals, the government has not argued that the president met statutory criteria for removal. Instead, it has insisted that those provisions are unconstitutional infringements on the president's Article 2 removal power, a position consistent with the president's recent executive order regarding independent agencies. Okay, here we go. Flipping. On that basis, the government appealed both orders. Let me put this back up here again. I'm hoping that the focus is okay, everyone. Move for emergency stays pending appeal. We considered the two motions together and heard oral arguments on March 18th of 2025. The presidential removal power. Before addressing the stay factors, it's prudent to address the text history. So this is a part I really wanted to share with everyone to give you again the other side of the story. Because again, you need both sides, then that way you can really truly pick which side you think is the best. And precedents that control this preliminary merits determination. With appointed positions when a new government. Exactly right, Ruth. Exactly. There are a huge number of people that will be removed and added when a new administration comes in. But you can't have everybody removed and added as soon as a new administration would come in, or else, there will be complete and total chaos. Here's our history. I begin with a review of our nation's founding period, the creation of our Constitution, and the historical practice in the decades that followed. Number one, the energetic executive. Here we go. Under the Articles of Confederation, we don't like the Articles of Confederation. I'm taking points off for that one. The early republic experienced the perils of having a weak executive with no executive separate from Congress. The federal government had to rely on the state's good graces to carry out national policies, and it was powerless to respond to national emergencies like the 1786 Shays Rebellion. As Henry Knox put it, the federal government was but a shadow without power or effect. Exactly. 5 points from Slytherin. Exactly. So when the framers met in Philadelphia in the summer of 1787, they sought to create a cohesive national sovereign in response to the failings of the Articles of Confederation. But the framers also understood that a strong federal government could be abused. They recognized that structural protections, most significantly, the separation of powers, were critical to preserving liberty. By splitting the legislative, executive, and judicial powers and giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of others, the federal government could avoid the gradual concentration of the several powers in the same department. To hire a whole new squad when you become president. Of course, right. The whole cabinet gets replaced, a whole bunch of people. Exactly. Yeah, exactly. Yeah, that's exactly what happens, right? But you can't replace 100%, right, of every single person that works for the federal government. And just to give you an example, what about, the federal clerk that's working for a district judge in the middle of Louisiana, right? Is she going to get fired with the next president that comes in and replaced with someone the president picks? Right? Because that's what we're talking about. We're talking about the clerk of court, the federal clerk of court, or the secretary, or the receptionist, or, the mail deliverer person. That's all federal employees, right? And if they are all just cut with the new administration, like, first of all, who's going to take that job? And second of all, it's, going to create chaos. The people at the top of those areas are the ones that can be moved and do get moved. So we just have to kind of keep that in mind. Next, after their experience with parliamentary supremacy, the framers were particularly concerned about the concentration of legislative power. For example, Governor Morris warned delegates of the Constitutional Convention that the legislature will continually seek to aggrandize and perpetuate themselves. True. Drawing on well established political traditions, the framers divided Congress into two chambers, the House of Representatives and the Senate. Whereas the framers divided the legislative power, they unified the executive. They were concerned that the weakness of the executive may require that it should be fortified. After the humiliating weakness of the Articles of Confederation, the framers deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of the laws, the protection of property, and the security of liberty. Get a federal job. Well, right. Well, yeah, I mean, and if you think about it too, like for the Attorney General of the United States, it's only going to be there as at the behest of the president. So if the president doesn't want her to be there anymore, he could fire her. Absolutely. And she may serve 4 years, she may serve 6 months. That'll be up to the president. There's a lot of positions like that. But again, the clerk in the middle of nowhere, Louisiana, that person whether they're hired and fired is going to be a little bit different, right? So this is the concurring opinion. It's written by Judge Walker out of the DC Circuit here. All right, here we go. So the framers debated how to achieve that objective while also avoiding the dangers of monarchy or tyranny. Some delegates proposed a plural executive branch to limit the concentration of power in any one person. For example, Edmund Randolph pressed for a 3-member executive representing different regions of the country. And some propose that Congress should choose the executive, whether singular or plural. How is the focus, everybody? Should I go back to using the pen? We're still kind of working through the details here, everyone, with the setup. Are we okay with the focus? It looks fine. Okay. We're going to try option 2, going back to using the pen, and then let me know if the focus is getting messed up again, all right? I'm going to test it out here on with our friends. Just let me know. All right, here we go. And ultimately, though, the framers insisted upon unity in the federal executive to ensure both vigor and accountability to the people. So they settled on a single executive, the President of the United States, who would be personally responsible for his branch. That unity affords the president decision, activity, secrecy, and dispatch, and it guards against a plural executive's tendency to conceal faults and destroy responsibility. It also avoids the habitual feebleness and deleteriousness that comes with a diversity of views and opinions. The diversity of views, my goodness. All right, am I still staying in focus here? It's getting blurry. Okay. Yeah, the pen blurs it, but I'd rather see the pretty nails than the pen. Well, I'm wondering. Okay, it's getting blurry. So, let me leave my sticky note here and then just see. What about now? Is it blurry again if I just use my hands? Maybe the color change is too much. How about now? Are we blurry? Let me see. Tea break. All right, yours is not blurry with the pen. Okay. Oh my goodness gracious, everybody. What would I do without you all helping me? Oh my gosh. I'm so thankful. Let me switch to your iPad. Okay. All right, well, okay, you're not blurry with the pen. And you're okay. Well, let's go back. Here we go. We'll use the pen again, everyone. Thanks for working with me here. I appreciate the help. Diversity of opinions, who wants that? It changes when your fingers move. The focus, really? Oh my goodness gracious. All right. So when I just point to the paragraph, it's not blurry, but if I actually put my hands in here, it's blurring. Don't really listen to me. Oh, I want everybody's opinion, unlike the executive branch. Oh my gosh. We'll get it figured out. We'll get into a groove here over here. We got to kind of reset our levels. So happy I find, oh, of course, of course. I've just got to get my levels worked out over here. My goodness. All right. Well, it focuses on what's closest to the lens. Ah. All right. Be your finger slightly closer to the lens. All right. I don't need to see it as long as I can listen. All right. Well, Well, let's see here. I've gotta have my pen so I can make notes and like stab at it. All right, well, we'll just keep running here. The blur isn't an issue. All right, well, we'll just keep going forward. As long as the sticky note can stay in, we'll just keep going forward. It can be like a radio show, everybody. All right, here we go. No diversity of opinions is where we left off. And at the same time, the framers understood the risks posed by a strong executive. Their solution, making the president the most democratic and politically accountable official in the government, subject to the election by an entire nation every. Now that's kind of weird though, all right? Because let's pause for a minute. Because they're saying the president is accountable because every single person elects him, but that's not true because we have the Electoral College. That's actually not true. 40 years, the resulting constitutional strategy is straightforward. Divide power everywhere except for the presidency and render the president directly accountable to the people through regular elections. So this is going to be the primary argument we're going to hear over and over and over again, everybody, from the government. This is it. This is the argument. We cannot divide the executive's power because if you pull any power away from the president, it goes against the original intent when they designed the government. That is the argument, all right? So keep that in mind. And I'm just going to highlight this because this is what we're going to hear 1 billion times over the next 4 years, all right? The power has to be condensed into one person because that is what the intent was. All right, number 2, original understanding of the removal power. Against the backdrop, the Constitution assigns a lofty role to the president. Article 2 vests the executive power in the President of the United States of America, and it charges the president to take care that laws be faithfully executed. Of course, the president cannot carry out his duties alone and unaided. He must enlist the assistance of subordinates. The framers envisioned a chain of dependence in the executive branch where the lowest officers, the middle grade, and the highest will depend, as they ought, on the president. The vesting clause empowers the president to direct and control those officials. As James Madison explained, if any power whatsoever is in its nature executive, it is the power of appointing, overseeing, and controlling those who execute the laws. That includes the power to oversee executive officers through removal. Because the Constitution provided no textual limits on the traditional executive power, it remained with the president. Founding era history confirms that understanding. The first Congress encountered the question directly, and its debate and decision, now called the Decision of 1789, well, that's original, provides contemporaneous and weighty evidence of the Constitution's meaning, since many of the members of the first Congress had taken part in framing that instrument. During the summer of 1789 ensued what has been many times described as one of the ablest constitutional debates which has taken place. the topic of the president's removal power came up during consideration of a bill establishing certain executive branch offices and providing that the officers, there we go, would be subject to Senate confirmation and removal by the president. The House debated various theories, including that Congress could specify the president's removal authority on an office by office basis, that officers could be removed only through impeachment, that removal required the advice and consent of the Senate, and that the executive power conferred plenary removal authority to the president. The last view, advocated by James Madison, prevailed. The executive power included a power to oversee executive officers through removal. To avoid giving the impression that Congress had any say in the president's removal decisions, the House deleted the bill's provision making officers removable by the president. In retrospect, the decision of 1789 has been viewed as a legislative declaration that the power to remove officers appointed by the president and the Senate is vested in the president alone. So I think one of the biggest issues, and something that we're going to be wrestling with, everyone, is of course the two ways of perceiving the Constitution, the two ways of implementing it, right? So one is that it is literally the exact words and intent as it was written at the time. The other is the intent looking forward so that it could move and be shaped with what was needed in the future. So those two ways of looking at the Constitution are what is in question here. All right. So are we looking at this as a situation where we're exactly wanting the historical intent of what the president was supposed to do at the time, or what the Constitution intended the presidential role to be as time went on? I mean, that's ultimately what our issue is here. So one of the things that I would recommend for everyone, when we're looking at this whole situation, this separation of powers issue between the president, the legislative branch, and the judiciary, is this will be a lot easier if we didn't have, an a-hole as the president. This would be a lot easier that way. But we do. But the question is, it's a valid question. What exactly is the boundaries of presidential executive power when it comes to removing federal appointees approved by Congress or approved by the Senate from federal boards? What are the parameters? I mean, that's one of the questions. Oh, and they're gone. Bye-bye. Kind of like the intent of the Second Amendment. Well, right. And again, the Second Amendment you didn't have a Second Amendment right until was it 2012, 2010, 2012? I always get it mixed up. No, was it 2008? Well, anyway, the point is you've only had a right to the Second Amendment for like less than 2 decades. And people don't realize that. But that's one of the things to kind of keep in mind. Let me just make sure here. I want to make sure I get the year correct. Let's make sure I've got the correct 2010. All right, it was 2010, but it's kind of weird because it was in DC in 2008 and then 2010 for McDonald's. All right. Okay. Right. So, that's the thing, is that we have lots of things in the Constitution that if we take it just at face value is absolutely not appropriate. It's just not appropriate anymore with where we're at in our society. So then the question becomes, at what point, in what places in the Constitution do we go verbatim what was intended in that moment, and which places do we not do that? And that, is one of the issues we're going to be dealing with the Supreme Court. You've got the originalists in there that are just like exactly what was supposed to be in that moment, and versus the non-originalists. And it's the debate that has been started since before the country was put together. Uh, right, right. Exactly, exactly. All right, so here's our historical practice here. Um, right. So, and the reason I bring this up, everyone, too, just a pause here, and I'm not going to get on my soapbox for too long here, but just a pause is that people are, they're stepping up and they're saying our democracy is in question. We're having, democracy's at stake right now, and we're dealing with fascism, or we're dealing with an autocracy or a dictatorship. And all of those questions, I think, are great questions to be asking right now, valid questions. But when we go through the cases on the closet docket, the actual lawsuits against the administration, I think it's important to do a case by case look to decide whether or not we're working on questions raised by the vagueness of the Constitution, as opposed to questions of removal of democratic rights. You know what I'm saying? So, with this particular case, we have two people removed from a federal board. They were supposed to have a 5-year term. We've got some precedent in the past that's kind of gone both ways, but now there's this question. We need to firm it up. Can a president remove people from the board like this? Two people. I'm this may not these may not be the cases, this particular one, where our democracy is in question. This could be a question of clarification in the Constitution, depending on how you see the Constitution. So I want to emphasize that because we really have a lot of things going on, and when it comes to the cases against the administration, there are some where we have a huge, democracy questions, but not all of them. We've got 160 cases going. So I don't want to, come on and be like, oh, we got 160 cases, our democracy's over. That's not true. I think there are some legitimate questions that can be answered. There are some stupid questions that should not have been raised, but I think in this particular case, I can see both sides of it. Which side I support is, not what the court decided here, but I wanted to just put that out there for everybody. All right, off the soapbox. Here we go, back in it. In it to win it. Historical practice. The understanding that the president holds unrestricted removal power became widely accepted during the first 60 years of the nation. George Washington removed almost 20 officers, including a consul, diplomats, tax collectors, surveyors, and military officers. We also only had 13 states. What's more, his commissions typically stated that office holders served during the pleasure of the president, indicating Washington's apparent belief that he could dismiss officers at will. Then, Secretary of State Timothy Pickering, the official in charge of signing commissions, confirmed the meaning of that language. Quote, in all cases except that of judges, it's been established from the time of organizing the government that, there we go, flip the page. True story, Kaya. True story. Removals from offices should depend on the pleasure of the executive power. Subsequent presidents also dismissed officers at will, often based on political disagreements. John Adams removed Secretary Pickering over a disagreement about America's alignment with France. That was a lot going on with that. Yes, the same Pickering who defended Washington's removal power. James Madison compelled the resignation of Secretary of War John Armstrong following the War of 1812. Andrew Jackson removed Treasury Secretary William Duane for his refusal to withdraw federal deposits from the Second Bank of the United States. William Henry Harrison intended to remove scores of Jacksonian officials, but died before he had the chance, just 1 month after entering office. That's a bummer for him. His successor, John Tyler, quickly carried out Harrison's removal plans. Not to be outdone, Millard Fillmore dismissed Zachary Taylor's entire cabinet as his first act in office. To be sure, these removals sometimes prompted minor opposition from Congress. For example, after Jackson removed Surveyor General Gideon Fitz, the Senate adopted a resolution requesting the president to communicate his reasons for firing Fitz to aid in the Senate's constitutional action upon the nomination of his successor. Jackson refused to comply with what he deemed unconstitutional demands. Presidents in our nation's first 100 years faced other similar half hearted resolutions in response to their exercise of removal power. One exceptional case was the impeachment of Andrew Johnson. So, in this, I think the judge goes through this, I think, in a very descriptive way that's easy for us to understand what happened here. The impeachment charged Johnson with violating the 1867 Tenure of Office Act, which required Senate consent to remove officers. So it was actually Johnson's impeachment had to do with this kind of an issue. Much of Johnson's defense centered on his view that the act was unconstitutional, a view the Supreme Court later endorsed. The Senate narrowly acquitted Johnson. The contentious Johnson episode ended in a way that discouraged congressional restrictions on the president's removal power and helped preserve presidential control over the executive branch. It now stands as one of the most important events in American history in maintaining the separation of powers ordained by the Constitution. A few decades later, another removal dispute arose when Grover Cleveland, he was such a jerk, everybody, this Cleveland guy, dismissed the U.S. Attorney Lewis Parsons prior to the conclusion of Parsons' statutory 4-year term. Parsons argued that the president could not remove him until the 4-year term elapsed. The court disagreed. After recounting the decision of 1789 and the continued and uninterrupted practice of plenary presidential removal, the court construed Parsons' 4-year term as a ceiling for how long he could remain in office, not as a restriction on the president's power to remove him sooner. As this history demonstrates, the founders understood that the president had invaluable and unlimited authority to remove principal officers exercising substantial executive authority, and presidents have exercised that authority since the very beginning of the republic, beginning with George Washington. B, precedent. And this is where the third judge who disagreed with this interpretation of the precedent here. With those historical underpinnings, I turn to the Supreme Court's more recent precedents. The court has reaffirmed the president's inherent removal power on several occasions, relying on the historical evidence recounted in the preceding section. That is not to say the court's removal power jurisprudence has always been consistent. Though the court in Myers reaffirmed the president's unilateral removal power, Humphrey's executor created an exception to the rule. It left future courts to decide when that exception might apply. To the extent that Humphreys created a showdown between the Myers rule and the Humphreys exception, the court's recent decisions have been unequivocal. Humphreys has few, if any, applications today. To discern the Supreme Court's rule, I review the court's holdings beginning with Myers. So then he goes through and talks through each of these cases, the precedent. And I'll just kind of flip through this for us as we go through. So we've got the Myers case. He does an analysis of that. Next, he goes through Humphrey's executor. I have to pause on Humphrey's executor, everybody. I just absolutely have to, because Humphrey's executor is one of the pieces in Project 2025 that was a goal out of the Department of Justice. One of the goals that was set out was to pull Humphrey's executor in and have the courts reanalyze it and pull it out with a different precedential ruling. That's exactly what's going on here, and that's exactly what Project 2025 proposed as a way to get its agenda going forward through the courts. So I have to just take a moment to say we have a court case with a specific goal in Project 2025, and that goal is what we're seeing happen here. All right, so there's that. Next, Humphrey's executor here, and then let me fast forward here as we go through this. Hello, welcome. Then we have the Wiener case. I laugh every time, everyone. I'm so immature. We have got the Wiener case, which is number 3. We have the Free Enterprise Fund case, which was number 4. And fast forwarding again here. Number 5 is the Seal Law case. So this is the law firm case. Oh, the Collins case. And keep flipping. And that was the last case. We had 6 cases that the judge reviewed here. Yeah, the Wiener. Oh my gosh. So those were the cases that he went through. And then he goes through and explains, how the doctrine is today. So he goes into the Humphreys exception. Again, I'm fast forwarding because there's more information. I laugh every time you look. You got to find your laughs where you can these days, everybody. You really do. And number 3, the stay factors. So this is one thing I don't want to spend too much time on, but the actual test for whether or not to have the stay in place or not, there's actually a test that has to be gone through. Okay, so we've got results coming in, not quite yet. Fast forwarding through this guy's opinion here so we can get to the next judge. So he goes blah, 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 blah. Let's get to the conclusion. Oh my gosh. I know, 2028, I know. It feels like this year's already been 100 years long. So here's our conclusion from the first judge writing the concurrence, and then I'll dive into the second judge who gives a little bit different take on it. But again, it's pretty similar. I'll just read through the first few paragraphs of the second judge. So here's the conclusion for the first judge. The district courts did their level best in rushed circumstances to follow Supreme Court precedent, but their fidelity to that precedent was unduly selective. By reading Humphrey's executor in an expansive manner, they read it in a manner that Seal Law and Collins preclude. Though those cases did not overturn Humphrey's executor, their holdings relied on an exceptionally narrow reading of it. Even the most casual reader will have guessed by now that I agree with how Seal Law and Collins read Humphrey's executor. But even if I disagreed with them, this court would lack the authority to undo what they did. For a lower court like us, that would be a power grab. So that's the conclusion for our first judge in that decision. And that brings us to Judge Henderson, all right, again, out of the DC Circuit here. She also concurred with the decision. I will just read her introduction again. We have concurring in the grants of the stay. I agree with many of the general principles in Judge Walker's opinion about the contours of presidential power in Article 2 of the Constitution, although I view the government's likelihood of success on the merits as a slightly closer call. Whatever the continuing vitality of Humphreys, I agree that we should not extend it in this preliminary posture during the pendency of these highly expedited appeals. So she's saying, we're just dealing with preliminary issues at this point. Let's kind of dig into this case, into the law later on down the road when we have more, the cases further down the litigation route. I write separately to highlight areas of the merits inquiry that remain murky and to emphasize that the government has easily carried its burden of showing irreparable harm, the second of the two most critical factors here. So she spends her concurrence going through and explaining how by not removing these two people off of these boards, how that is irreparably harming the president. So that's what she spends her time on, everyone. Now we will fast forward again until we get to the third judge. So we have that dissenting opinion here. So we go through, blah, 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 blah. Here we go. So this is the dissenting judge. And it's Judge Millett here. And again, I'll just read through the first couple of pages to give you an idea of what the argument is of the last judge. Sorry, tea break, everybody. Tea break. All right, here we go. We're in it to win it. We're going to make it through here. The two opinions voting to grant a stay rewrite controlling Supreme Court precedent and ignore binding rulings of this court, all in favor of putting this court in direct conflict with at least two other circuits. That's a good point. The stay decision also marks the first time in history that a court of appeals or the Supreme Court has licensed the termination of members of multi-member adjudicatory boards statutorily protected by the very type of removal restriction the Supreme Court has twice unanimously upheld. Yes, she certainly did. What is more, here, I think it's a she. I apologize if it's not. I'm assuming it's a she. What is more, the state order strips the National Labor Relations Board and the Merit Systems Protection Board of the quora that the district court's injunctions preserved, disabling agencies that Congress created and funded from acting as long as the president wants them out of commission. So, okay, it is Patricia. Great. So let me pause for a minute here. This is a really good point, all right? And she goes on about this. Her issue is not necessarily, she's not necessarily arguing the nuances of the law in this moment. She's trying to say if you pull them off the board like this both of these boards are going to be basically defunct, not able to function for an extended period of time here. And so what she's saying is this manner in which this is done is harmful. That's her take on it. And I thought that was really interesting. That decision will leave languishing hundreds of unresolved legal claims that the political branches jointly and deliberately channeled to those expert adjudicatory entities. In addition, the majority decision's rationale openly calls into question the constitutionality of dozens of federal statutes, conditioning the removal of officials on multi-member decision-making bodies. Everything from the Federal Reserve Board and the Nuclear Regulatory Commission to the National Transportation Safety Board and the Court of Appeals for Veterans Claims. That would be an extraordinary decision for a lower federal court to make under any circumstances. But what makes it even more striking is that all we are supposed to decide today is whether a stay pending appeal should issue. So she's also saying that the court's going well beyond what the actual question before it is. As to that narrow question, the stay decision is an unprecedented and, in my view, wholly unwarranted use of this court's stay power, which is meant only to maintain the status quo pending the appeal. So again, she's looking and saying, well, the reason why we are even doing a stay is so that we don't jack everything up while the case goes through the process. And then she's citing the NK case here. A stay simply suspends judicial alteration of the status quo, which is defined as the state of affairs before the removal orders were entered. Here. Have to have a quorum. Exactly right. Exactly right, VC. They just aren't able to function when you do it like this. So, they can't get the work done until this gets sorted out. So, I think it's a valid point. I cannot join a decision that uses a hurried and preliminary first look ruling by this court to announce a revolution in the law that the Supreme Court has expressly avoided, and to trap in legal limbo millions of employees and employers whom the law says must go to these boards for the resolution of their employment disputes, I would deny a stay. So that's her perspective of it, and I think it's valid. I think she has a valid point. So and then she just goes on to support where she's coming from on that. So with that dissent. So let me reorganize my papers here because I want to ask, what do you think? Do you think everything that we're doing is a balancing test, right? So we're balancing the role that the executive branch has in executive federal agencies and the purpose, the power of these agencies to in the president versus well, if you shake everything up all at once, nothing's going to get done. Like, what's more important? Is it more important to have compliance with what the elected president wants? Or is it more important to do it in a way where the government doesn't need to completely get shut down and nothing gets done? So which one's more important? That's the question here. Right? And to me, I would say it seems like we need legislation to, one of the things that we do with law firms when we are getting ready to close a law firm is that we have a wind down process. Same with companies, with businesses, you have a wind down process. So it seems like it would be in everyone's best interest to have kind of a wind down process. And that's something we've never had before, right? So when a new administration comes in, start the process of winding everything down. Because if you're just cutting and cutting rather than winding down, then everything just gets all tangled up. That's my personal perspective of it. In full control of the board at any time. Right, agreed. I agree with that. And that's one of the reasons why, too, they're trying to make it so that it's offset, of course. Right. Although, and that's the question, though. Like we say, well, we don't want one party to control the board, but technically, that board is a function of the executive branch. So then the question becomes, what is the scope of the power of the executive branch over these agencies? And that answer was, it's up to Congress. And so now the question's becoming, well, Congress answered it, but we don't think it was right. We don't think they answered it the right way. So that's a huge issue right now. Because we want boundaries put into place, or we want, qualifications put into place. Congress writes the laws, right? Because the president doesn't make law, but then the president's coming in and saying, but I don't like what you wrote. So I want something different. Like, go back. I want a different rule in place. Right? Of the order conclusion. The order conclusion here is the stay was granted. All right. The reason why that's important is because originally the restraining order was granted, putting them back on the boards. They'd been fired. The restraining order said, no, put them back on the boards until we're done hashing this case out. And then they appealed. Now the stay then reverses the restraining order and pauses all the lower stuff until, so they're off of the boards until the issue is hashed out. Does that make sense? Apparently he's trying, well, right. I mean, if you're going to give Congress, if Congress has the power to set out the rules, then, why does the president get to come in and say, I don't like your rules? That's the question. Like, that's the rub of the situation. Like, the president has the executive branch and has these agencies, but federal law sets it in Congress's hands to define the boundaries. So it's, this is where we have this constitutional question where why does the president get to come in then and say, I don't like what Congress did? And I don't think the judges should even get to hear it, right? So that's, we're talking about constitutional questions, but then we're also talking about, well, they're doing what they're supposed to be doing. They had jobs, got fired, got ordered back, now refired for now. Yes. That's exactly right. Oh my gosh. Because this whole question is, can the president remove the members from the board? That's the question. That's so funny. But yeah, you're right. You're right. Yep, exactly. Also happens to be, oh, interesting. Yeah, I'm not surprised. I'm not surprised. Oh my gosh, keep them away from Social Security and Medicare? No. They're already, what is it, like shoulder deep in that business. That's already done. They're already in there, man. Sorry about that. Keep having issues with, well, right. So the other thing too is, if you try to ask legally, like, what's your end goal? What are you trying to get to? Are you trying to get people that you want on the board so they will implement and follow what your administration wants? Is that your goal? Or is your goal to, keep the government from functioning properly so you can kind of just do whatever you want while everyone's scrambling to get everything to work again, right? So that's where the questions come into play as well. If you really wanted to change this, is that really what your goal was? Or is there something else that you're trying to do? Oh, I know. Seer colleagues, welcome her back. Oh, the whole situation is so horrible. It's just, yeah. Again, this whole idea of just like, cutting it, that's one of the things too. If you think about it with Jack Smith, when all of this started winding down after the election, and Jack Smith's like, here's my report, and then I'm out, and he got out of town because, this kind of stuff was going to go on. And that was a smart move. And a lot of other people left too that technically were probably, weren't political appointees, and could have kept their job, but just knew, like, with this new administration, that I'm going to get canned. So I'm getting out of here while I can. Yeah, disability benefits. Yeah, I mean, it's an incredibly stressful time right now. The cuts are being cut, and they don't care who gets hurt. They've got the role that they've got their goals, and they're going towards the goals there. Yeah. I mean, it's very, very frustrating. It's difficult. It's hard to watch. For sure. All right. Do we have any new? I'm sorry, everybody. I'm already like, what's going on in Wisconsin? Do we have any news? Do we know what's happening in Wisconsin? Any word? They can't collect unemployment. Right. Now that I don't know. That's a really good question. I don't know about the unemployment, but I would say, depending on the way that they were terminated is going to be really odd. And I think anybody trying to do unemployment right now is going to be questionable because all of the agencies are kind of jacked up right now. Well, right. And, I think, yeah, I just, they get to eat a vote. Right. Even if you keep your job, you may be asked to do unethical things. Exactly right, Ruth. And that's a lot of what was going on in the Department of Justice. So multiple attorneys resigned. I mean, it was like a mass exodus, because at the end of the day, you have your everybody's got boundaries. I mean, at least we thought everybody was supposed to have boundaries. I know one of the things over the last year when people were debating, which way to vote, one of the biggest questions was always, well, where's your line? Where's the line of what someone could do so that you wouldn't vote for that person? Where's the line? And some people, it's like they didn't have the line. And that's like, mind blowing. Like, what do you mean you don't have a line? How is that possible? Okay, only 1% in. All right, all right, all right. Yeah, we're gonna have to wait. But right, but that was the big question. Like, what is it that we're going to say is too extreme? And some people, it was eye-opening moment to realize that nothing. And all of a sudden, we were just like, okay, that wasn't on my bingo card. There seems to be none. I agree. There really are some people, and then also too the power play. Like I think in this country, we always, take a look at the power play because then we're thinking like, oh, Captain America is going to come in and knock over the bad guy with the power play, and like that's not happening. Like these people are like there's like 100 Lex Luthers right now in Congress. It's just it's odd. It's just very odd. Trickle down economics. No. Oh my gosh. There doesn't seem to be any possible benefit to anyone. Yeah, I mean, oh yeah. Keep in mind, bigger precincts. Right, right. True, true, true. True. Good point. That's a really good point. With that. So, all right. Oh my gosh, Wisconsin. What are we gonna do? What happened in Florida, everybody? I was reading the document. Update me on Florida, would ya? I'm like, what happened? Keep me updated. We had 2 seats in Florida. Do we have some idea of how they went? Good news, bad news, medium news? Depends on how you define good and bad, I suppose. Right? I'm on the edge of my seat here. What happened? Both in Florida were called for Republicans. Okay. But were they close though? I mean, that's the other question. We don't have that, dominance anymore. Now we're kind of like, blah. Okay. Didn't see. Okay, so Republicans won. So the goals to bring back the golden age. Yeah, which was expected because there were, well, yeah, that's the thing is just to have made this kind of a dent in the area is, I mean, it's good to note. And the number of people that even went out and voted, I think, is a win. That was what, I thought a lot of people say like, oh my gosh, this is why you lost the election. The reason why the election was lost, if you want to say that, is because of voter turnout. And the voter turnout situation was, that was it. That was what lost. Now, why they didn't go out and vote, that was the problem. 30 minutes after the poll closed, House poll. Yeah, they go quick, don't they? Right? Yeah, it goes quick. 57-42. Okay. Oh my gosh. All right. Wow. I mean, and again, these were like there wasn't even a question before, but now has been so much publicity. And 56-42, I think that's respectable so far. Again, we don't know. 1890s. That's not a good time. Like we didn't have well, I don't want to say we had huge plague outbreaks because, that was just a couple of years ago here. So, okay, 57-42. That's pretty stinking amazing at this point. Again, we don't have final numbers, but again, it was a good fight. It was a good fight. And the fact that there was a fight at all, I think is excellent. Yeah, exactly. exactly. Cutting them, exactly. So, and the other thing too, some people may say this is predictive of the midterms, but I'm not sure that that's true when you're dealing with areas that are just so clearly red. To be able to chip away at that, I think it speaks volumes. I know, it's terrible, isn't it? It gets worse as the night goes on with more tang. The humor gets worse. Oh my gosh. I know. I know. Right. So, okay, so the Florida didn't flip the way we wanted, but that's all right. It was still a good fight. Corey was amazing today, fighting an amazing good fight, standing up and, uh, you know, teaching people that it's okay to stand up and yell about what's going on. And then now we are waiting on Wisconsin, right? Not enough precincts reporting yet. So, yeah, I mean, it doesn't seem like everything's ending. The world's not ending in this moment, right? Don't need their oh my gosh, Cynthia, can you imagine? I can't. I can't even imagine there is this delicate line that is being walked between finding out what happens when you do this to a level so that you understand and it helps you make choices in the future to help yourself versus like, don't take me down with your ship and your learning experiences. Like, I don't want your education to take me down with it. Ah! Oh my goodness. They were nervous enough to adjust. Yes, I saw that. Exactly, Ruth. Exactly. So then the question is, that could be seen as a win. That was a win ahead of the game. But still, even with these two seats, though, that majority is still so slim, everyone. There's no way to get any kind of amendments through or any of that. Every single piece of legislation is going to be a fight. For sure, for sure. Yeah, I mean, it's a kind of a weird situation. Doesn't watch the news. Right. I mean, you're gonna have to wait until they're like, wow, I can't buy any more eggs ever. I laugh so I don't cry, everybody. All right. It's really very difficult, very difficult. So security just got a few. Oh, okay. Well, there we go. We like to see that. We like to hear silver linings, we got to somehow figure out how to make it through this whole process. Yeah, shift. Yeah, exactly. And VC, that's the thing, is we're going to keep seeing that over and over and over again. I mean, there's a moment where everybody has to make the choice. Like, is this what you want or not? So, right. Health reasons. I got it. I got that. Yep. Oh, that's a good point, Cynthia. The snowbirds aren't citizens in Florida. Oh, that's interesting. Lost half their support. Yeah, exactly. Tea break. True story. True story. Yeah, so those numbers are a little bit weird. Yeah, Florida's got a little different dynamic going on there, for sure. All right, so I am going to be back again on Thursday, everybody. And Thursday, again, we've got the JGG hearing. So I will walk everybody through what happened during the hearing and the most recent order from JGG. We do have an order out of the Court of Appeals. Let me just make sure. Here we go. This is like 100 pages. Yikes. So this is the most recent order that we've got, the March 26th order upholding the restraining order on the executive order on the Enemies Aliens Acts, right? So that's the most recent, and this did get filed on the 26th. So I will be going through this and also updating everybody about what's going on in the hearing, and I'll do kind of like a Q&A. So for anyone who does hang out in the hearing or is watching the news, we can kind of come together and we'll debrief the hearing and then go through this most recent order. So that will be my plan for Thursday. And again, I will be Tuesday, Thursday, Sundays for the month of April here as we get things changed. And I appreciate everyone kind of helping me out with my focusing issue here. You know, I'm kind of getting everything restructured here. So as we move to the new house, I appreciate it. But hello. Yes, of course. Hello, H. Titus. So with that though, everyone, I know we're waiting on those numbers to come in, and I'm hoping there are some others on live out and about. So I will go ahead and say fare thee well for tonight. I appreciate you all coming by and hanging out. And Kaya, you've been working so hard. All the moderators have been working so hard today. The last couple of days, moderators, you are just angels, all of you. I appreciate it so much. No worries, Navy Vet. No worries. I'll be back around. So with that, I will sign off for now. We really don't know the status of the talk at the moment, so absolutely making the move over here. So I don't have my long content going as much as the short content over here. I'm still trying to figure it out. With that, have a great night, everybody. Fingers crossed for Wisconsin. We shall see what happens. And I'll see you on Thursday, everybody.